All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the second webinar of our 2025 Education Law Series. This webinar is called the Marjory Stoneman Douglas Act, Teacher with Guns. Before I introduce our speaker, I do want to go through some quick housekeeping announcements. This training is being recorded, so if you're registered and you were unable to attend, you're going to be receiving a link via email from Zoom. We will also be posting it on YouTube as well, so be on the lookout for that within 24 hours. If for whatever reason you don't see the email, you cannot find the recording, you can always just email me directly. I'll make sure I'll get it to you. This training was approved at the Florida Bar for one General CLE and one certification credit for education law. I will announce the CLE code towards the end of the webinar. I will drop it into the chat. I will also send it in the email, and you will be able to find it in the YouTube description as well. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or the captions, you can reach out to me directly. This training is being co-hosted by the Public Interest Law section of the Florida Bar, or PILS. And if you're not familiar with PILS, I'm going to encourage you to look at their website and their social media links. It's a pretty cool section. They have a lot of working groups that you may be interested in. So I'm going to drop that information into the chat so you can check them out. Final piece of housekeeping announcements are questions and answers. If you have any questions, try using the Q&A feature on Zoom. You can ask your questions there, and we'll do our best to address all the questions towards the end. And I think that's my last housekeeping announcement, so I'm going to go ahead and introduce our speaker today. Beverly Brown is a passionate legal advocate and lifelong educator with extensive experience in educational advocacy and Social Security appeals for children with disabilities. A former Equal Justice Works Fellow at Three Rivers Legal Services, Beverly has represented students in due process, Section 504, and ADA matters across 17 Florida counties. She now provides pro bono services through Southern Legal Counsel. Beverly also has a rich background in teaching and program development and remains committed to empowering children through individualized advocacy. So, without further ado, it is my pleasure to pass it to Beverly. Beverly, the floor is yours. It's yours. Welcome back.
Thank you, Jorge. I'm really excited to be here today. This is a very poignant and triggering topic. So if anyone gets upset, I understand. If you need to leave our presentation, I'm going to try to make it as beneficial as possible. So what we're going to talk about is how the Marjory Stoneman Douglas Act affected education and some of the changes that have occurred because of the Marjory Stoneman Douglas Act. Marjory Stoneman Douglas Act was established after the horrible event that occurred at Marjory Stoneman Douglas High School in February, I believe it's 2017. There were 14 students and 3 staff members who passed in the shooting, and 17 individuals were injured. What Marjory Stoneman Douglas Act attempted to do for the school system was establish or create the Office of Safe Schools, which is part of the Department of Education in Florida. Also allowed sheriffs to establish the Coach Aaron Feist Guardian Program, which sometimes you see referred to with 3 names, Chris Hickson and Coach Scott Beagle as well. It launched Fortify Florida, a mobile suspicious activity reporting tool. It established new requirements for mental health services and training. It established requirements for safe school officer at each public school, and it mandates school safety assessments for each public school. So it was very ambitious, and in 2018, they implemented it and expected everybody to hit the ground running. In addition to the effect that it had on school systems, the law was changed in Florida to require individuals to be 21 to own long guns. So individuals had to be 21 if they wanted to have ownership of rifles and shotguns. That law was repealed in 2025 in March, and it's been lowered. The age has been lowered back down to 18. So moving on, how did we end up here? There are a few cartoons interspersed while you're looking at the cartoon. I will share with you in the chat. Jorge is going to place a link to a study that was done since 1999. And you might say, why 1999? Well, in 1999 was Columbine, and since Columbine, there has been a lot of data collected about shootings in the United States, and this particular study it breaks down where the shootings have occurred, how many gun incidents are happening each year throughout the United States. So I thought that was something you might be interested in. The Marjory Stoneman Douglas Act is seen as pushing children to the juvenile justice system. So if you, thank you, Jorge. How is that and why is that? Because many of the hopes of MSD was that it would help students by providing more guidance. But in response to the multifaceted needs that were proposed in the act, it seemed to have hardened responses to what seemed to be sometimes normal youth behaviors or bullying or mental health needs. I'm going to talk about all of these things, but the anonymous nature of Fortify Florida, which is a bit scary if you're not familiar with Fortify Florida, the broad definition initially of threat and variability among the threat assessment, which has changed because Florida in 2022 has standardized the threat assessment process, the lack of due process when there is an allegation of a threat, the problematic nature of information sharing. So when you have all of these young people and all of these individuals who can anonymously share information about their disabling conditions, their Baker Acts, trouble with law enforcement, etc. The black box of data that has become the Office of School Safety. So all of this information that's being collected about all of these individuals, and this is seen, all of this together is seen by some advocates as exacerbating existing school to prison pipeline inequities. The Marjory Stoneman Douglas Act, through this statute, Florida Statute 1006.12, was to establish one safe school officer at each school. So that can be done in several different ways. There can be a school resource officer who's employed by a law enforcement agency, and in some counties you'll see it happen that way. It can be a school safety officer who may be employed by the district or the school board, or it can be a school guardian, which are armed school employees who are authorized to act in active assailant incidents at school. And that was the impetus for the title, Teachers with Guns. So not all teachers are packing heat or carrying guns. There are very specific requirements for school guardians. So in an effort to help you understand this, the requirements have been spelled out. A sheriff must at a minimum provide access to coach and vice guardian program to aid in prevention or abatement of active assailant incidents on school premises. As required under this paragraph, persons certified as school guardians need to have no authority to act in any law enforcement capacity except to the extent necessary to prevent or abate an active assailant incident. So these individuals are only trained to the extent that they would be involved in an active assailant incident. A sheriff who establishes a program shall consult with the Department of Law Enforcement on the programmatic guiding principles, practices, resources, and shall certify as school guardians without the power of arrest school employees as specified in this particular statute. And then they outline in the statute the training, which is quite involved. So they have to have a valid license issued. They have to complete 144 hours of training, which consists of 12 hours in diversity, 132 hours of firearm safety, proficiency conducted by criminal justice standards, and training commission certified instructors, which may also include 80 hours of firearms instruction, 16 hours of instruction in precision pistol, 8 hours of discretionary shooting instruction using state-of-the-art simulator exercises, 8 hours of instruction in active shooter or assailant scenarios, 8 hours of instruction in defensive tactics, and 12 hours of instruction in legal issues. And it continues. There are requirements that the individual who wants to be a guardian, next slide please, pass a psychological evaluation administered by a licensed psychologist, and designated by the Department of Law Enforcement. Those evaluations have to be submitted to the sheriff's office. They have to pass an initial drug test and subsequent random drug tests in accordance with the requirements, and successfully complete ongoing training, weapon inspection, and firearm qualification on at least an annual basis. So although we kind of said tongue in cheek, teachers with guns, as you can see, this guardian program is not something that would be for someone who wasn't taking it seriously. Very involved. And here is one of the cartoons that came out when this was first being proposed. So you have a very heavily armed individual saying, "Hi, Susie, I'm your new math teacher. Your English teacher is over behind the barricade." If you don't know what else to do, try and laugh. So what training is missing from the Guardian program, according to some advocates? Well, just basic child development training, maybe training about trauma-informed practices, the mental health first aid training, conflict de-escalation and reduction training, or training about unique populations, disability training. So that training often occurs in schools, and many teachers have those types of training, and that's not to say that these guardians don't possess training in those areas. Moving on, so the guardian piece is quite complicated. This piece, Fortify Florida, you may have seen and not realized what you were seeing. At least that's how I came upon it. Fortified Florida is a way to allow anyone in the state of Florida to anonymously report suspicious activity about students in or outside of school. And the concerns that an attorney might have would be over that young person's privacy and using that data. The Department of Education is acquiring all of this data and collecting it, and it's shared with law enforcement in a kind of shared repository. The next slide you're going to see is what this looks like. So on any any school website, any Department of Education website in Florida, you should see the icon Fortify Florida. And through Florida Statute 943.082, it allows individuals to report any individual in school for suspicious activity while remaining anonymous, to school officials and law enforcement. So that is one piece of the Marjory Stoneman Douglas Act. At each school and in each district, they will have a point of contact regarding school safety. And at each particular school, they will have someone designated as a threat assessment team. Now, when this law first came out, this, if you're in the educational system or you know of people in the educational system, this was quite a mess. Everybody had to have a team for threat assessment, and no one really had an idea of what the threat assessment was supposed to look like, and people were using all kinds of different instruments, etc. So if you'll go to the next slide, it is the Florida Administrative Code, and it outlines what a threat assessment team looks like. So the threat assessment team is established at each school to examine the students' actual behavior. So if somebody makes a threat or does something that's threatening in nature, then the team is supposed to come together immediately and examine this situation. Each school district has to adopt policies that are consistent with the rule and model the policies developed by the Office for Establishment of a Threat Assessment Team. The district threat assessment policies have to include procedures for referrals to mental health, and hopefully they have mental health systems that they can refer to. Each school's threat assessment team is supposed to include persons with expertise in counseling, instruction, school administration, and law enforcement. So it's not just one individual, but has to be somebody from each of those areas. The counseling team member must be school-based mental health. The law enforcement member must be a sworn law enforcement officer. A school guardian, as defined under the section 1006 Florida statute, or a school security guard, is defined under the other Florida statute that's listed, may not serve as law enforcement. So it has to be a law enforcement member. And the instrument is based on that they must use is something that has, at the time, originally was used throughout the school. Now I have shared with you with the materials that you can find at the end of this webinar, the Department of Education in 2022 has developed a uniform instrument that is used throughout the state of Florida. So you have what is called the best practices for threat assessment teams, I believe, or model of best practices. Okay, so what is a threat assessment? It is an initial evaluation. It's supposed to occur same day. And you think about this, I mean, you just heard who's supposed to be on the team. So mental health, law enforcement, somebody responsible for education, all of these people are supposed to convene, and it's supposed to occur the same day that the threat has occurred. And it's almost as if the individuals in a school have nothing else to do, and we know that's not the case. So this can be quite a burden. The threat assessment team leader works with another member to complete this paperwork that has to be submitted. If violence appears imminent, they have to follow crisis procedures. Each school has some sort of crisis procedure that is established. Sometimes that means that they call a crisis response team, or that they call law enforcement to see if the Baker Act is necessary. There's usually some sort of protocol for a crisis. Once violence is no longer imminent, the threat should be evaluated. An interview should occur of the person making the threat, even when the threats are transient. So even when they know that the threat is not something that is serious or something that is transient and that it can't be foreseen, that something that is not going to happen in the future, they still must go through this process. So what are the key questions for a threat assessment? What were the students' motives or goals? How did they come to someone's attention? Has there been communication suggesting an intent to attack someone? Has the student shown inappropriate interest in school attacks, weapons, or mass violence? Has the student engaged in attack-related behaviors? Does the student have capacity to carry out the targeted violence? Which are how the threat assessment needs to start. Is the student experiencing hopelessness, desperation, or despair? Which, sometimes students feel that way just because of their age and hormonal changes, and sometimes things are going on at home. So a lot of students have big feelings. Does the student have a trusting relationship with at least one adult? Does the student view violence as an acceptable or only way to solve a problem or solve societal issues? Is the student's story consistent with his or her actions? Are other people concerned about the student's potential for violence? And what circumstances might affect the likelihood for attack? So those are the questions that went into formulating the threat assessment that is currently being used. There is, like I said, there is one that is now sanctioned for the entire state, which is much improved since the initial Marjory Stoneman Douglas rollout, when everybody was using a different assessment. I did go on today and try to download the threat assessment, and the link that was provided in the document that I've provided you did not open. So unfortunately, I don't know if that means that they are changing the threat assessment in Florida or what, but you do have a document that does have a link to it. So hopefully at some point it will be available. Okay, all of this increased surveillance happened because of Marjory Stoneman Douglas. The FDLE created a centralized integrated data repository and data analytics resources, and the consolidated data comes from where? From social media, from VCF, from the BLE, or from VJJ. And this encourages vast information sharing despite confidentiality. So some of the things that as an advocate you have to be aware of is that your client, if they are a child, is exposed to a lot more violations of their privacy through this particular act. And it's done in the hopes that we won't have more school shootings, and in the hopes of preventing these things. But this increased surveillance has become counter to some of the things that we zealously advocate for. Some people have stated that Marjory Stoneman Douglas has increased the school to prison pipeline. I have just stated some of the reasons that students are kind of pushed from school to prison, but the reason that individuals have seen MSD as one of the factors increasing the school to prison pipeline is that policies and practices push them out of the classroom into juvenile justice. So you have the impulsive middle school student who says, I'm going to shoot you, I'm going to kill you in a moment of jest, and that is a threat, even though that student doesn't intend to act upon it, then they are up for expulsion or pushed out in some kind of disciplinary procedure. What are the things that increase this pipeline? You have low expectations from teachers, low engagement or lack of trust or relationship, poor school relationships, low academic achievement, incorrect referral or categorization in special education. So maybe they've been found eligible, but are not receiving the right kind of services. There's a lack of stakeholder participation in decision making. You have over-reliance or zero tolerance practices, punitive measures such as suspensions and expulsions. So, most students are disciplined by pushing them out of school. If they're in trouble, they have to stay home, and they aren't building their academic skills or their social skills when they're staying home typically. There's an over-reliance on law enforcement tactics and a ceding of disciplinary authority to law enforcement personnel, and school-wide impact of trauma, which can be sometimes secondary. So you see students getting involved in some very negative situations and that they can't get out of. The school to prison pipeline disproportionately affects students of color, students with disabilities, students who are identified as LGBTQIA, and girls, and especially students who are at an intersection of one or two of these categorizations. Something that you need to be aware of is the school environmental safety incident reporting system, which is, and this slide is very difficult to read, and I apologize. I tried to correct it, but it doesn't look like I did much good. It's referred to as CESR. CESR discipline refers to things that occur at school that are automatically reported to law enforcement. And if you were working with school-age children in a legal capacity and you've collected discovery, sometimes you discover these things without realizing, without the parent knowing that these things have happened. So for example, let me give you an example. A student is 5 years old and was crawling behind another little student, and it was a male student crawling, in kindergarten, crawling behind a little girl, and he touched her bottom, while he was crawling behind her playfully. And it was coded as sexual assault on a disciplinary referral. And the sexual assault was then sent as a CESR violation to law enforcement. So if certain discipline categories automatically are sent to law enforcement, and parents don't always know they're there, which is kind of a terrifying thought. I've come across this with several of my clients in the past, like um, working with a 15-year-old student who in third grade had an aggravated battery. When he was in school, he was just sent home for 2 days, but there is a law enforcement write up with this child's name on it. And I think the fear is that one, the parents aren't always aware that these things are being reported to law enforcement. And two, when the student is older and then is involved in something else, law enforcement already has a record of the student from when they're much younger. So it exacerbates law enforcement's dealings with the student. Um, the categories are very difficult to read, but it's things you know you would think would be crimes: criminal mischief, major disruption, grand theft, murder, kidnapping, fighting, sexual assault, sexual offense, simple battery, alcohol related, aggravated battery, arson, bullying, burglary, harassment, hazing, homicide, and kidnapping. But some of these things are erroneously coded or coded in such a way for very young children that don't need to have an event with law enforcement at such a young age. But that's the Cessor reporting system. Okay, so what are some considerations when you have these young people and you have to provide a defense, either criminal or in some sort of school related case? How did this get to juvenile justice? Did the victim file a report versus information sharing and local law enforcement discussion versus school police? How did people find out about the threat? Was it a Fortify Florida versus formal bullying report versus word of mouth? And if you're not familiar with the bullying reporting procedure, that's something that Florida has made available to everyone through the Department of Ed, and every school district has forms that anybody can report bullying, and it's kept in a student's folder if that happens. Who was involved and what were their roles? What was the determination of the school threat assessment? Was it substantiated versus unsubstantiated? What was the school's response? And these are kind of complicated. And if you weren't here with us last week to talk about the responses, tier one refers to response to intervention or a multi-tiered system of support. ESE is exceptional student education. Follow-up, so are they looking to provide the student with supports or services? Exclusion would be out of school suspension or expulsion. Alternative school is another school setting. So, and they've listed expulsion. So exclusion then would be out of school suspension, and expulsion would be out of school for a period of time that's significant. Usually expulsions are recommended for 1 to 2 years. Who is this child? Was the school aware they were bullying, if being bullied at the time? Does this child have a disability, and does that matter? Those are the things you need to consider. When you're working with this child, what are your discovery considerations? Now, with all of this data, any and all threat assessments or documents associated with threat assessments would be something you'd want to gather. Any tips generated in Fortify Florida, anything associated with documentation from school safety, who knows what has been collected. What did law enforcement receive from the school? Was it forwarded to out of school suspension? Was it forwarded to the Office of School Safety? If there's a bullying history, were there any bullying reports? If they're disabled, do they have an IEP, 504 plan? Are there progress notes? Were there functional behavior assessments? Were there behavior intervention plans? Were there discipline referrals? Were there any manifestation termination meeting minutes? Was there training and disciplinary records? Were there school policies and practices related to roles and responsibilities that deal with the behaviors that you're seeing with your particular client? Okay, just some general advocacy points. A clearly defined role for law enforcement in schools as protection, not discipline. And I think that's kind of difficult sometimes because often the school resource officer is there all day. So somebody who's in a uniform there all day gets involved in disciplining students, and that's not how they should be functioning. Required training and de-escalation techniques, adolescent development, and implicit bias for law enforcement and anyone armed on campus. It's important that individuals realize that kids are going to be kids, that we all have biases, and it's important that individuals working with kids understand how to de-escalate. I know I've been in situations where school staff, I've probably been the one to do this myself, having worked with kids many, many years. School staff pushes a child into a corner, not literally, but verbally, just upset that the child won't give their name, or upset that the child won't obey the instruction. And I've seen school staff do things that definitely escalate the behavior versus de-escalating the situation. Requiring annual psychological evaluations and drug testing of any armed individuals on campus, which is necessary. Increased involvement of school counselors in discipline policies and procedures, and focus work on improving, protecting school climate through restorative strategies, programs, and other effective school discipline. There's a lot of work being done with restorative justice programs, and it has been very effective. It's just difficult for some schools who are shorthanded and are having a hard time dealing with all of the responsibilities that they have to be on top of all of these wonderful programs that are available for effective school discipline. And usually the ones that are having the most trouble are the least able to prepare. Some more general advocacy points. Limit school counselors' non-counseling responsibilities. So every school has guidance counselors. Some schools even have psychologists, but typically there are guidance counselors. And if you ever met a guidance counselor, they will tell you they don't have time to counsel frequently, unless it's a really unique situation. They're usually dealing with grades and transcripts and all kinds of paper pushing things that have to do with students and their transcripts. But if you could limit that and increase their ability to work with the students and guide them, that would be helpful. Increase local and state funding for programming to improve executive functioning, decision making, stress management for everyone involved in the school system, and protect student privacy. That's really a key point I want to emphasize. I'm not sure how we do that in Florida in this current climate with Fortify Florida and all the sharing of information from social media to DCF to law enforcement, but protecting students' privacy is paramount. Okay. So what happens when you have a child who's disciplined and there needs to be a change of placement? If you have a student who's disciplined and there are more than 10 days of out of school suspension, if that child has any disabling condition whatsoever, it requires a manifestation determination. So I would default to they probably do. There's probably ADHD. There's probably something going on that we could say that is a unique ability, that they're suffering emotionally, they have trauma, something is happening, or they wouldn't be pushed out of school for more than 10 days. So a manifestation determination meeting needs to occur. When the manifestation meeting happens, then they need to either put changes into the IEP, or it's determined that it's not a manifestation of the student's ability or disability, and they are put out of school. If it's determined that it's not a manifestation of the student's disability and they're placed out of school, they can be placed in an alternative setting or they can be expelled. If it's determined that it is a manifestation, then they must remain in their current setting, they must be given extra supports, and they must be provided with compensatory services for the time that they've missed. There are special circumstances where you can't argue it's a manifestation. You can try, but typically if there are drugs involved, weapons involved, or serious bodily injury involved, then students are going to be disciplined for those issues, expelled or placed in an alternative setting, even if they have a disabling condition that they have an emotional challenge or they have behavioral issues. It just isn't going to rise to that level, and those are the special circumstances. If you do have a situation where there was a manifestation determination conducted and you are not happy with the outcome, you can always have an expedited meeting with the Division of Administrative Hearings and argue that the outcome was incorrect, and the hearing officer or the ALJ, the administrative law judge, can return that individual to their current placement and order compensatory services, or say that they need to be in interim alternative educational placement for 45 days. But typically that's better than an expulsion. An expulsion can be a very, very negative thing for a young person to go through. A 2-year expulsion rarely has a positive outcome. If a child is expelled from school for 2 years, they're likely to drop out of school. That's been my experience. I'd love for you to share experiences with me that were different. if you have them at the end. Okay, persons with disabilities in discipline cases, you would look to 20 USC 1415K, Section K, which is under IDEA. You would express concern in writing for this individual. So you might have a student who is in trouble and they haven't ever been identified, but he or she is now your client, and you're going to claim this student should have been identified. The teacher or other school district personnel may have expressed concern about a pattern of behavior with this individual. All of these things will support a manifestation. You requested an evaluation for eligibility, and if all of these things prove to support you, the child should remain in placement and evaluation must be expedited. So if an individual is in need of services and hasn't been identified, and they've gotten themselves into a disciplinary problem, and you know, or someone realizes that they've had this pattern of behavior over time, then we're asking for an evaluation. And while we're asking for it, they need to stay where they are while this evaluation is expedited, which means it needs to happen more quickly than the 60 days that are the legal requirement for the school district to conduct a psychoeducational evaluation. Okay, so I think we made it through the slides. This is like, I thought this was a short video, but I don't think you can access it. It is a picture of the individuals who lost their lives at the Marjory Stoneman Douglas High School. And there was some organ music, and it just had their names, but I thought it would be a nice way for us to kind of pay homage to them. If you have questions, I would be more than happy to try to answer them. I hope that you have learned something today.
Thank you, Beverly. We do have a few questions that were posted in the Q&A. Timing wise, these were asked around I'm gonna go back on the slides to kind of put it into perspective. I believe they were, no, let me go forward a little bit. They were asked around here, when you were discussing the school to prison pipeline. The
Yes.
first question is if they find that there is a credible threat and the child ends up in the juvenile justice system, what happens when they are released? Is there a rehab component to this, and do they reintegrate back into public schools?
That would depend on the level of the threat. Most individuals end up going back into the public school, but you know, if someone has committed a shooting in a school and is being tried as an adult in Florida, many young people are moved out of the juvenile justice system. So I mean, that question is kind of hard to answer. It just depends on what the threat is and what county it's in and how willing they are to work with the family and the child.
There was a follow-up question right after this one. I'm not 100% sure if it's the same. It's a follow-up question on this one, but the question was, does this apply to public schools and private schools?
So interestingly, they have changed the they're now adding it to private schools. So I know that the guardians are being trained now for private schools. Um, I don't know if the private schools are required to use the same threat assessment from the DOE. I know that charter schools would be because they have the same requirements as public schools. But I'm not familiar if private schools have to use these same documents from, I would think not, just because they're not required to do much of what the DOE expects. Um, but they do, private schools can have guardians now, and the training does occur for private schools.
Let's see if we have, I don't see any other questions in the Q&A. Double check the chat just in case. I don't see Gloriana raise her hand. Gloriana, if you have, I think I can bring you off mute. I see some hands raised. I'm not sure if they want to ask questions, but if that's the case, let me. Oh, yeah, don't worry. It was by
We have
mistake.
time. I'd be happy to answer what I can.
I'm gonna go ahead while if people have to ask questions, I'm gonna drop the CLE code in here. Into the chat. As I said earlier, this was approved for one general CLE credit and one certification credit for education law. The CLE code is 2504819N. I also dropped the link to the materials. All of this is going to go out via email as well. In the materials folder, you're going to find a copy of the slides, and you're also going to find a copy of a threat assessment that Beverly shared. And I also added a it only has one link so far, but I also added a Google document that has some resource links as well.
Thank you, Jorge.
Okay, we're still here in case we have any questions. Let me stop sharing.
I appreciate everyone joining us. Next week we have Parent Rights Act.
Yes, I'm gonna just in case you haven't been able to register, I'm about to drop the link in here as well. It's next week at noon. So we kind of turned this into a Wednesday series. I think we did that on purpose, but it worked out very well. Go ahead and drop it off. And here you go. All right, so I guess if we don't have any questions, then we can wrap up a little bit early. Let's see if, yeah, we have some thank you messages in here. Thank you again, Beverly. Great presentation as always. I'm looking forward for the next one. So everybody, have a great rest of your day, and I will see you at the next one.
Thank
Bye.
you. Bye.